When you have a practice that 80% of the public thinks, violates the preferred practice, they should have an explanation in the courts as to why, from the courts as to why this is allowed to occur.
The U.S. Supreme Court giving Illinois Congressman Mike Bost a victory yesterday in a ruling saying he has standing to sue the State Board of Elections over ballots being counted 2 weeks after an election year, or an election day. It is Illinois in Focus Daily. I'm Greg Bishop. Wake up with us each and every weekday morning here for the latest. And we've been watching the U.S. Supreme Court closely for a whole host of other issues outside of Mike Bost's challenge that he brought several years ago, including the gun ban challenge that the Supreme Court is set to go into conference to consider tomorrow, and that challenge coming out of Cook County. But you also have other litigation within the U.S. Supreme Court that's impacting Illinois, including this case coming out yesterday. So a lot of different things happening, and at the U.S. Supreme Court, they ruled that Congressman Mike Bost, he does have standing to sue the State Board of Elections. Another headline from the Center Square: U.S. Supreme Court allows Illinois rep to sue over late ballots. Andrew Rice reporting for the Center Square. He reports that the U.S. Supreme Court in a 7-2 decision said an Illinois congressman has the right to sue over counting federal election ballots beyond Election Day. Mike Bost of Murfreesboro filed a lawsuit against the state in 2022 for counting ballots postmarked on Election Day up to 2 weeks later. The court affirmed Bost had legal standing to sue without addressing whether states could allow mail-in ballots received after Election Day to be counted. Chief Justice John Roberts, in a majority opinion for the court, said individuals who sue must display a personal stake in a case to have standing as a candidate for office. Roberts said Bost had that standing. A candidate has a personal stake in the rules that govern the counting of the votes in his election, Roberts said. A candidate who expends additional resources or undergoes reputational harm will be affected by unlawful election rules, he said. He argued in his opinion, the majority opinion, that candidates also have an interest in fair election laws. Candidates are not common competitors in the economic marketplace. They seek to represent the people, and their interest in that prize cannot be served from their interests in the electoral process. In their dissents, you have Justice Sotomayor and Ketanji Brown Jackson taking issue with Roberts' claim that candidates have a special interest in the fair election process, which gives special rules for standing. They wrote in their dissension, in a democracy and democratic society like ours, the interest in a fair electoral process is common to all members of the voting public. The court thus ignores a core constitutional requirement while unnecessarily thrusting the judiciary into the political arena. So this question about should Illinois count ballots past Election Day, and that really also ties into the issue of mail-in balloting. And during COVID, we saw universal mail-in balloting in the state of Illinois, and now you see universal permanent mail-in balloting, where you can request a permanent mail-in ballot where you will get a mail-in ballot for every election instead of going to the polls or requesting an absentee ballot. We really don't have absentee ballots anymore. Anybody can vote from home and either give it to somebody to then put it into a drop box, and that raises concerns about ballot harvesting. There are obviously laws against that in Illinois, but there's an interesting little loophole with the drop boxes. When you have a mail-in ballot, you yourself can take your mail-in ballot and put it into the drop box, or you yourself can take your mail-in ballot and hand deliver it to the county clerk before the election. You can't do it after the election. Once election day is over, then they start getting the stuff from the mail up to 2 weeks. But the loophole that hasn't really been addressed by the State House is somebody else could go around and grab ballots from a whole community, and if they take that and physically hand it over to the election clerk at your county, that clerk is going to look for some kind of signature from the voter over to you to say, I am handing this ballot to this individual to turn in. That's when they go physically to hand it hand to hand to an election official at the county level. That same type of oversight isn't had at the drop boxes. So you could grab a whole bunch and put them into the drop box, and there's no county clerk there to see if you have that signature handing over the voter's ballot to you to be able to drop into the drop box. So I mean, the mail-in balloting thing is something that obviously is going to have to be addressed. But to this issue of this particular case, it didn't have to do with any of that. The case in front of the U.S. Supreme Court that Mike Bost ultimately got was about standing, and that standing, whether or not Bost had the right as a candidate to sue the State Board of Elections over the 2-week counting. Now, they haven't even gotten to the merits of that question of the can they count federal election results up to 2 weeks after an election day. President Donald Trump's been adamant, saying that number one, we need voter ID. Number two, he doesn't like mail-in balloting, says there could be fraud, so he wants states to do something about that. Congress could change the law to impact federal elections, but that could bifurcate the ballot in Illinois if Illinois wants to continue allowing for mail-in ballots to be counted up to 2 weeks. If Congress was to pass a election day only vote and maybe a high threshold for absentee ballots that could be voted, that could bifurcate the election to have a state election and then the federal election. If the state continues doing 2 weeks after the election to count mail-in ballots with universal and permanent mail-in balloting, but the federal election only allows so much, you can consider the amount of burden that could put on local county clerks, especially when our elections don't include just federal offices, it includes state and local offices as well. So that issue about mail-in balloting has not been addressed yet on the merits, right? The first little preliminary issues that made it up to the U.S. Supreme Court with the opinion coming out yesterday was just about standing. So now this case has to go back down and be dealt with on the standing issue. But it's not the only case out there that is dealing with this. Our reporter Katrina Barker, she talked with Russell Noble, that's Mike Bost's attorney, and he says that the next step they have yet to finalize, and they could depend on developments in a similar case out of Mississippi.
Same thing in Mississippi. If the Supreme Court says ballots received after Election Day violate federal law, then yes, that should apply elsewhere.
So he went on to discuss this issue and what exactly was central to it in the conversation.
Now, keep in mind that this is a pre-election suit, not a post-election suit, and so the court made clear that the standards differ depending on when that is.
He also said the case was filed before any votes were cast, and
when you have a practice that 80% of the public thinks violates the preferred practice, they should have an explanation in the courts from the courts as to why this is allowed to occur.
So next steps in this case going to be watched closely, especially with what happens in Mississippi. And we're in an election year. Is this going to impact the 2026 election? I guess it depends on how fast the district courts, the appeals courts, and elsewhere deal with this question. All right, it's Illinois in Focus Daily. Wake up with us here each and every weekday morning. I'm Greg Bishop. Thank you so much for being with us. And stay tuned and like, subscribe, and hit that notification bell. Get the newsletter in your inbox for thecentersquare.com.